thank you everyone for joining us. I would like to present my guest, Tracy Kayser Esq. Thank you so much for joining us this evening and sharing your wisdom and expertise. So, first I wanted you to just tell us a little bit about yourself. How did you become an attorney? Why did you choose trusts and probate?
I was a realtor before I was a lawyer. And so I sold real estate for about 7 years. And then I think I just wanted a little bit of a higher education. So I wasn't sure I wanted to be a lawyer, but everything I did as a realtor, which is negotiations, advising, working with clients, it really kind of fit into the law field. So I went to law school, and when I got out, I actually did more litigation than I did estate planning. But my mentor, who I worked for as a law clerk when I was in my last year of law school, was a probate attorney, and he knew me pretty well, and he said, Tracy, one day you got to get back into real estate and probate. So I did litigation for about 7 years, and then he was exactly right. I decided that it would be a kinder, I thought it was a kinder, gentler area to do trust and estates. Well, not really, because families fight. And so,
yes.
But I love what I do. So I started my own practice about 11 years ago. And I've been doing drafting trusts, doing probate, trust administration, conservatorships, guardianships. I stay in that little probate world as much as I can, and I do real estate also,
Okay.
stuff, and I love it.
Fantastic. So tell me, why does someone need a trust? What does that mean? How does it protect somebody?
In California, and also in a lot of states, especially in California, if you own assets, whether it's real estate, whether it's a car, whether it's bank accounts, if you own an asset that's over $150,000, or it's actually now $166,250, you are going to be in probate court. And what that means is that your assets that should go to your children, should pass to your children without having anybody's eyeballs on your estate, will be seen by anybody who wants to go to the court and open up the accounts or open up the files. So if you own anything over $150,000, which means if you own real estate at all, most real estate's over $150,000, you have to have a trust.
Okay.
That's one of the reasons. The other reasons is because you want to do family planning. You want to pass your estate on to your children tax-free, and you want to be able to give to who you want to give your stuff to.
Okay, that makes sense. Now, so if someone doesn't have any property, then they don't need a trust? Or if you were saying if they own a bunch of classic cars and it totals up to $160,250 or whatever you said, then they would?
Yes, exactly. If you owned one Lamborghini, you'd need to be in probate.
Okay, good to know. So what is the purpose of a trust?
What a trust does, a trust allows the people who create it, they're called trustors or settlors, to assign their assets, their home. I don't usually do cars and trusts, but bank accounts, all their real estate, investments, stocks, bonds, mutual funds, they transfer it into the trust. And what the federal government is allowed is when you have a revocable living trust, you are able to pass on your assets to your children without court intervention at a much less expensive cost to the family. And the children also receive their assets with a step up in basis on capital gains. So in other words, you don't have to pay usually capital gains tax. It depends on when you sell the asset. And there's benefits to property taxes. So really a revocable living trust has a massive benefit, and it really starts at a small level. Parents give their kids stuff, and then it goes all the way up to massive asset protection planning. Families who have $20 million or even more, I have some attorneys who do $80 million estates, and they're having to not only do a revocable living trust, but irrevocable trust and a bunch of different types of vehicles to avoid estate taxes.
Okay. Wait, so when you're saying, what's the difference between the irrevocable and the revocable trust?
A revocable trust is a trust that the people who create the trust They can revoke it by ripping it up the next day. They can amend it by changing it, going back to the attorney and saying, look, I'm not interested necessarily in having this person be the successor trustee. I want to name this person, or I want to give my kids this, or I want to add a charity. I want to give to a charity. It's controlled by the settlors, the people who made the trust. So usually it's a mom and a dad, and the children are the beneficiaries. An irrevocable trust, you have to name a third party to be the trustee. You do not have control over the trust. And you usually can't amend it without court intervention. It's much more difficult. So when you set up an irrevocable trust, you got to be careful. You need to know why you're doing it.
Okay, very good. Interesting, interesting. So what's the difference between having a will and a trust?
A will is an instrument that allows a person to transfer their estate to the named individuals inside the document. But that will is going to be submitted to the court for the purpose of a probate. When you have a will, you are not avoiding probate. When you do a trust, you are. And when you do a revocable living trust, you should have with it a pour over will. So when I draft a trust, I'm not doing just a trust. I'm doing a trust and a will and a couple of other documents with it.
Okay, so you should have both then.
Absolutely.
Okay, very good, very good. So how does a trust work in terms of, like, if somebody becomes disabled or they need care for, because like now they can't take care of themselves or whatever, how does that work? And is that a conservatorship or is that different?
Sometimes you can get away without a conservatorship because, I'm doing a conservatorship for a gentleman who has a trust right now, but because he has a brain injury, he's acting like a crazy person. And so you can't really control him with your trust documents. So you have to get more power, which is given through the courts. So a trust does allow you to be able to deal with incapacity. And in the trust that most attorneys draft, there's a provision that says, what happens if I'm incapacitated? And when I'm incapacitated, I'm going to name a successor trustee who will step into my shoes and who will, while I'm still alive, but I may not necessarily have the capacity, will help me with banking, will take me to the doctors, will do all those kinds of things. If you can accomplish that in a trust, which you can, then you can avoid the conservatorship. I try to avoid conservatorships at all costs, but sometimes you just can't.
Okay. Interesting.
Yep.
Now, how often does a trust need to be updated when there are like life-changing events?
I think it needs to be updated about every 5 to 10 years. But honestly, if nothing changes in your life, I'd say come back and have it reviewed after 10 years. Life-changing events are the death of the spouse, which means one of the trustors passed. Got to update your trust or basically do a trust administration.
Okay.
When something happens to your children, when you want to name a different beneficiary or trustee, and sometimes doing a change to a trust can be a simple small amendment, a little 2-page document that is attached to the trust. I've had people come to me after 20 years of not having their trust looked at, and we do what's called a restatement. We revise the whole trust, refresh it, give it new provisions because California law or federal law has changed. And as an example, with the new administration, we may have big changes and we need to plan for that. The other thing is Proposition 19 passed last year. So we have to plan for that too in terms of how property passes to children. So depending upon what's going on in the environment. But I would say every 10 years have it looked at. And if somebody comes to me after 20 years, I'll restate their trust.
Okay. And then just like ballpark figure, like how much does a trust cost? Like, is there a range from A to B or like depending on how much stuff you have, or how does that work?
Yeah, it's kind of all of it. So trust, when you're married, the documents tend to be twice the amount of a single person because you have that many more documents. So when you're a single individual or widowed and it's just you, maybe not your spouse anymore, just redrafting a trust may cost a couple $1,000 up to $3,000. If you go to, I hate to say it, to Newport Beach or Laguna, it all of a sudden gets to $4,000 and $5,000. If you're married, usually the trusts are around $3,000, $3,500, and they go up from there. So if you're doing a very, very large estate, it could be 4,000 or 5,000, 6,000. I do know some attorneys who this last year, when they did Proposition 19 planning, they charged $20,000 for a
Whoa.
change to the trust. Yeah.
Wow. So
Yeah.
since you've already kind of touched on it briefly with the changes of Proposition 19, can you kind of expand a little bit more about that? Or
Proposition 19 changed the, well, it did a couple of things. One, it allows an individual who owns a piece of property, who's lived in that property for a period of time, to move county to county and keep their property tax basis. That's a benefit. That's a blessing.
right.
I do not see Prop 19 as a great thing, because I believe that what it's doing is it's going to force a lot of properties that are legacy properties to be sold, such as a Beverly Hills mansion that at some point in 1970 was purchased for $2 million. Maybe it's worth 20 now. The property taxes will be reassessed to the children, because if you and what Prop 19 says is, if you are a child of a parent that's passed away, the only way to get the property tax basis that the parent had, which could be very, very low, is you have to live in that property and call it your primary residence. If you call it your secondary residence, it's fully reassessed to the current rates
Wow.
as of today. And that
Wow.
will be forcing a lot of sales.
Wow.
That's
Okay.
that's the Cliff Notes version.
Okay.
So
Okay. Now, who would be a good person to have as the person's trustee? Like, is it better to have family, friend, or like a third neutral party, like a CPA or something? Like, what would you recommend?
If we have husband and wife and they have children, and the children are older than 20, 25 years old, I tell the parents to name the children if they're responsible. If the children are not fiscally responsible, then we try to go somewhere else, such as a CPA, a professional fiduciary. But I try to keep it in the family, because banks, institutions, and professional fiduciaries charge a fee, and it could be very expensive to have a third party manage a trust. So I like to keep it in the family.
Okay, good to know.
Yeah.
And then, so does a living trust avoid estate and probate taxes?
No, a living trust will avoid probate, and all the probate costs that go along with it. So, but well, I mean, let me say yes and no. If you have a very, very large estate, right now, the law says that each spouse is entitled to about $11.5 million in an exclusion before they get taxed with their on their estate. So both married couples have to be worth over $22 million to be taxed. If the new if the new administration changes it to what they've been talking about, which is 3.5 to 5 million, there's going to be a lot of us paying estate death taxes, and that means it could go up to 45%. So you're not only taxed when you make the money, you're taxed when you let go of the money. And it's actually, to me, it's yucky. I mean,
well, and that's a huge difference from, you said 11 million to like 3 or 4.
It's rough. We're gonna have to wait to see what the administration does.
Wow.
And that's going to require people to come back in and to do planning.
Now, are there any drawbacks of a living trust?
Yeah, I kind of don't see any. I mean, I really think that it's really the way to go. If you don't have a lot of assets, you don't need one. You can do a will. For instance, I have a couple who came in today. They have a mobile home. A mobile home is considered a vehicle, and they don't have assets of 166,250. So I just did a simple will for them, and that should be fine. But most of the time, trusts are quite beneficial. I will say this: a trust costs anywhere from, let's say, $2,000 to who knows what. A probate, the same trust, if I do a trust for a $400,000 estate, $400,000 home, or $500,000 home, my fees may be $2,000 to $3,000. My probate fees will be $15,000.
Wow,
starting.
That's a huge difference.
Yeah, starting.
Now, how can viewers learn more about you and your business?
They can go to my website, which is kayserlawgroup.com.
As always, if you or anyone you know is looking to sell, buy, or invest in real estate, I'm at your service, and I'd be honored to help you achieve your real estate goals. So thank you so much for joining us, everyone.